Constitution of India. This is a new subject introduced by Kerala Technological University for 4th semester B.Tech students in their curriculum. So here's the first module: definition of constitution, historical background, salient features of the constitution. Then comes the preamble of the constitution, union and its territory. Then finally meaning of citizenship, types, termination of citizenship. Indian Constitution, otherwise known as Bharatiya Samvidhana, is a supreme law of India. A constitution is otherwise a set of fundamental principles or established precedents according to which a state or other organization is governed. Even the parliament cannot override the constitution. Next, we will see the need of a constitution. First, it generates trust that is necessary for different kinds of people to live together. Next, it specifies how the government will be constituted, which means who will have the power and what decisions will they be responsible for. Next, it lays down the limitations on the powers of the government and makes a citizen aware of their rights. Fourth one, it expresses the aspiration of people for building a good society. A good society is one where people enjoy their freedom without compromising on law and order, and everybody is treated equally irrespective of caste, creed, gender, and ethnicity. Next, it defines the nature of political system of a country. And finally, it provides a set of rules that allow the minimal coordination among members of society. Society comprises of different groups with diverse language, religion, region, ethnicity. Constitution ensures stability in the society. They establish rules and regulations to govern all and prevents chaos in the society. Actually, the people don't know their true power. That's why we need a constitution. Constitution, the people and the government are the two main parts. And the government is elected by the people itself. Next, the main characteristics of Indian Constitution. It is the longest written constitution and it is partly rigid and flexible. And ours is a democratic republic country where the head of the state is elected by the people. Our constitution defines a parliamentary system of government where cabinet is formed by the parliament and the parliament is the superior organ. There are two executives, that is the elected president and the prime minister. It defines the fundamental rights and duties of a citizen. It is a moral obligation of all citizens to help promote a spirit of patriotism and to uphold the unity of India. It also defines the directive principles of state policy. It is a guideline aimed to create social and economic conditions under which the citizens can lead a good life. Principle emphasize that state shall try to promote welfare of people by providing them basic facilities like shelter, food, and clothing. As per the Indian Constitution, ours is a secular government where the government is neutral in all matters of religion. Also, we have an independent judiciary which should be independent from the other branches of the government. That is, courts should not be subject to improper influence from the other branches of government or from private or partisan interest. And also, our constitution gives us the right of single citizenship, where all the people, irrespective of the states or territories in which they reside, are the citizens of our country. As I said earlier, constitution comprises of the people and the government, where the government has mainly three bodies, namely legislative body, judiciary body and executive body. The legislative body is an agency which has a responsibility to formulate the will of the state and vest it with legal authority and force it. Judiciary, it has a responsibility to apply the laws to specific cases and settle all disputes. And executive body is responsible for day-to-day management of the state. These three bodies are considered to be the three main organs of the government. Next we will see the history of Indian Constitution. The British came to India in 17th century initially for trading only. Eventually, after slowly gaining more power, they attained the rights to collect revenue and govern themselves. In order to do this, they enacted various laws, rules and regulations. Next came the Charter Act of 1833, where the Governor General of Bengal became the Governor General of India. It also created a central legislature, which in a way made the British supreme rulers of India. The rule of the company itself finally ended with the Government of India Act in 1858. As a result, the British Crown became ruler of India and administered the country through its government. The Indian Council Acts of 1861, 1892 and 1909 started giving representation to Indians in the Viceroy's councils. They adopted decentralization of powers between the central and provinces. The Government of India Act 1919, where the Legislative Council came into existence, is all provinces of the government. For the first time, people could elect their own representatives through direct election. And finally came the Indian Independence Act of 1947, which marks a final step in the departure of British from India. India became a truly independent and sovereign state after this act. The act established governments at the central and provincial level. It also laid down the foundation of the Constituent Assembly. And finally, after independence, the assembly elected by Dr. Rajendra Prasad as its chairman and began drafting the constitution. Here in a nutshell you can see the making of Indian Constitution. In December 9, 1946, the first meeting of the Constituent Assembly was called, and in December 11, 1946, Dr. Rajendra Prasad elected as a president, and in August 29, 1947, drafting committee was appointed, and in November 4, 1947, drafting constitution submitted, and in November 26, 1949, drafting was completed, and in January 24, 1950, the handwritten constitution was signed and it was legally enforced in January 26, 1950, which we are celebrating as Republic Day of India. Overall, 2 years, 11 months and 18 days were taken to prepare by the final draft. And the authors were Benegal Narsingh Rao, B.R. Ambedkar, Surendranath Mukherjee and other members of Constituent Assembly. And here you can see Baba Sahib Ambedkar presenting the final draft, and in 1950 the Constituent Assembly meeting, and finally Jawaharlal Nehru signing the Constitution. Next we will see the preamble of Indian Constitution, which is known as the preface of Indian Constitution. The preamble can be referred to as the preface, which highlights the essence of entire Constitution. The preamble to the Constitution of India is a brief introductory statement that sets out the guiding purpose and principles of the document. The first words of the preamble, "We the people," signifies that the power is ultimately vested in the hands of the people of India. So far, the preamble has been amended only once in 1976 by 42nd Amendment, which inserted the words socialism, secularism, and integrity. Next, we will discuss the most important words that has been explained in the preface of Indian Constitution, that is a preamble. First one is sovereign. The word sovereign means supreme or independence. India is internally and externally sovereign. Externally free from the control of any foreign power, and internally it has a free government which is directly elected by the people and makes laws that govern the people. The term socialist here means democratic socialism, that is, achievement of socialistic goal through democratic, evolutionary, and non-violent or socially equal means. Next, a secular state is an idea pertaining to secularity whereby a state is or purports to be officially neutral in matters of religion, supporting neither religion nor irreligion. Government respect all religions. Liberty. The idea of liberty refers to the freedom on the activities of Indian nationals. All citizens are secured with liberty of thought, expression, belief, faith, and worship through the fundamental rights. Democratic. The first part of the preamble, we the people of India, and its last part, give to ourselves this constitution, clearly indicate the democratic spirit involved even in the constitution. The people of India elect their governments at all levels by a system popularly known as one man, one vote. Next comes republic. A democratic republic is an entity in which the head of the state is elected directly or indirectly for a fixed tenure. The leader of the state is elected by the people. Justice. The term justice in the preamble refers to three varying aspects: political, social, and economic, which are secured through different provisions of fundamental rights and directive principles of state policy. Liberty. The idea of liberty refers to the freedom on the activities of Indian nationals. Equality. This envisages that no section of the society enjoys special privileges and individuals are provided with adequate opportunities without any discrimination. And finally, fraternity. This refers to a feeling of brotherhood and a sense of belonging with the country among its people. So these are the words which has been explained in the preface of Indian Constitution. Next, we will see the structure of Indian Constitution. Currently, the Constitution of India has 448 articles in 25 parts and 12 schedules. Also, there are 104 amendments that have been made in Indian Constitution up to January 25, 2020. The very first amendment in the Indian Constitution was made in 1950. The individual articles of the Constitution are grouped together into different parts. Part 1, Union and its territory. Part 2, citizenship. Part 3, fundamental rights. Part 4, directive principles of the state policy, etc. Next, schedule. Schedule of Indian Constitution are basically tables which contains additional details not mentioned in the articles. The first schedule contains a list of states and union territories and their territories. The second schedule contains provisions of the President, Governors of State, Speaker and the Deputy Speaker, Chairman and Deputy Chairman of the Council of State, the Judges of the Supreme Court and High Court, and the Controller and Auditor General of India. The third schedule contains a forms of oath or affirmation, and the fourth schedule contains provisions as to the allocation of seats in the Council of States. The fifth schedule contains provisions as to the administration and control of scheduled areas and scheduled tribes. The sixth schedule contains provisions as to the administration of tribal areas, in the state of Assam, Meghalaya, Tripura, and Mizoram. The 7th schedule contains the union list, state list, and the concurrent list, and the 8th schedule contains the list of recognized languages. 9th schedule contains provisions as to validation of certain acts and regulations. The 10th schedule contains provisions as to disqualification on ground of defection. That means to abandon a position or association of one to join an opposing group. The 11th schedule contains the powers, authority and responsibilities of panchayats, and the 12 schedules contain the power, authorities and responsibility of municipalities. Next, the amendments. As of January 2020, there have been 104 amendments of the Constitution of India since it was first enacted in 1950. There are 3 types of amendments to the Constitution India, of which second and third type of amendments are governed by Article 368. The first type of amendment includes that can be passed by a simple majority, more than half of the total, in each house of the Parliament of India. The second type of amendment includes that can be effected by the Parliament by a prescribed special majority, that is 3/5, 3/4, etc. in each house. And the third type of amendment includes those that require, in addition to such special majority in each house of the Parliament, ratification by at least 1/2 of the state legislature. Next comes the Union and its territory, which comes under Part 1, Article 1 to 4. Article 1 of 1 states that India, that is Bharat, shall be a union of state, and Article 1 of 2 states that states and territories will be specified in the first schedule, and Article 1 of 3 states that the territory of India will comprise the following: the territories of the state, the union territories mentioned in the first schedule, and such other territories as may be acquired. Article 2 deals with admission or establishment of new states. Article 3 states that the Parliament may by law form a new state by separation of a territory from any state, or by uniting 2 or more states completely or in parts, or by uniting any territory to a part of any state. And Article 4, it says that any law referred to in Article 2 or Article 3 will contain such provisions for the amendment of first schedule and the fourth schedule necessary to provide effects to the provisions of law, and may also contain such supplemental, incidental and consequential powers as a Parliament may deem if necessary. Next, we will see the Citizenship Act of 1955. An Indian citizen is one who was born in India, or either of whose parents was born in India, or who has been ordinarily resident in India for not less than 5 years can be a citizen of India. There are 4 ways in which Indian citizenship can be acquired, that is by birth, by descent, registration and naturalization. By descent, it comes under Section 4 of the Act. A child born outside India between 26/1/1950 and 9/12/1992 shall be a citizen of India by descent if the father of the child was an Indian citizen by birth at the time of the birth of child, or in case the father of child was an Indian citizen by descent at the time of birth of the child shall not be a citizen of India by birth unless the birth of the child is registered with the concerned Indian mission abroad within 1 year of the birth. Approval of the central government is necessary in all such cases. Similarly, a child born between 10/12/1992 and 2/12/2004 outside India shall be a citizen of India by descent if either of the parents was an Indian citizen by birth at the time of birth of the child. The birth of the child is to be registered with the concerned Indian mission abroad within 1 year of the birth. Approval of the central government is necessary in all such cases. A child born outside India on or after 3/12/2004 shall be a citizen of India by descent if either of the parents is an Indian citizen at the time of birth of the child and the birth of the child has been registered with the concerned Indian mission abroad with 1 year of the birth, and the parents of the child have to submit a declaration that child does not hold passport of any other countries. Here also approval of the central government is necessary. Citizenship by naturalization can be acquired by a foreigner who is ordinarily resident in India for 12 years and fulfills other qualifications as specified in 3rd schedule to the Act 1955. He should not be an illegal migrant also. By registration, a person of Indian origin who is ordinarily resident in India for 7 years before making an application for registration, or a person of Indian origin who is ordinarily resident in any country or place outside undivided India, or a person who is married to a citizen of India and is ordinarily resident of India for 7 years before making an application for registration, or minor children of persons who are citizens of India, or a person of full age and capacity whose parents are registered as citizens of India under section 5.1.a or 6.1, or a person of full age and capacity who or either of his or her parents was earlier citizen of independent India and has been residing in India for 1 year immediately before making an application for registration, or a person of full age and capacity who has been registered as an overseas citizen of India for 5 years and who has been residing in India for 1 year before making an application for registration. Next, by birth. This comes under section 3 of the Act. Every person born in India on or after 26/1/1950 but before 1/7/1987 is a citizen of India by birth irrespective of the nationality of his or her parents. Every person born in India between 1/7/1987 to 2/12/2004 is a citizen of India, provided either of his or her parents is a citizen of India at the time of his or her birth. Every person born in India on or after 3/12/2004 shall be a citizen of India, provided both of his or her parents are citizens of India, or one of whose parents is a citizen of India and the other is not illegal migrant at the time of his or her birth. Finally, the termination of citizenship, which comes under section 9 of this Act. The Constitution of India provides single citizenship. It means an Indian person can only be a citizen of one country at a time. If a person takes the citizenship of another country, then his Indian citizenship ends automatically. However, this provision does not apply when India is busy in war. Thank you all, and these are my references.